I'm Susan Allen, Benefits Coordinator with the Greene County Council on Aging.
I'm Dave Cusack of Cusack Law Office in Beaver Creek, Ohio.
We'd like to invite you to join us for our legal chat, brought to you by the Greene County Council on Aging. Let's talk about probate. I have a lot of people who just freak out about probate. What is that?
Yeah, so we hear that a lot. People have a fear of the legend of the evils of probate. But probate's just a process. It's a process that's court supervised for administering assets of someone who those assets don't manage to avoid probate, and account for appropriate debts, take care of taxes and so forth. But it's a probate supervised process, a probate court supervised process.
So if I have a will, though, then I don't have to do probate, is that right?
That is not correct.
Oh.
So the issue about, we hear that all the time, that I avoid probate because my will says this goes to my son. But the will applies only to probate assets. So let's kind of think of it as an example. Well, let's talk about what a probate asset is. A probate asset is an asset that doesn't automatically transfer to someone else by the manner in which it's owned. So let's say you have a 401k and you name a beneficiary. If that beneficiary survives you, we don't have to ask probate court to help. We don't have to look at a will. You fill out a claims process as the surviving beneficiary and that asset goes to you. If you own a house jointly with a spouse, and it's a survivorship deed, we don't need to ask the probate court to assist in that process. We fill an affidavit out after the first spouse has died. We file that with the death certificate in the recorder's office. Those are examples of non-probate assets. Let's say that you own your house just in your name. You pass away, not married. Where does that go? Now we need the probate court to help us out. That's a probate asset.
So if I just own my house, and I don't have a joint survivor, is there a way I can pass it on without probate? There
is, and actually, real estate's a really good thing to talk about in that context, because when people, with their inherent fear of probate, they hear there are ways to avoid probate, they kind of jump on that. So let's say that house, you wanted to avoid probate and go directly to one person. You can do what's called a transfer on death designation affidavit, and that asset would then transfer just like any other beneficiary designation, as long as that person survived you. Now, if we have multiple beneficiaries, that becomes more cloudy. You have 3 or 4 beneficiaries of a bank account or an investment account. That's not a big deal. It's going to divide evenly, right? Mm-hmm. And it's going to just go directly to them. If you name 3 people as beneficiary of your house, that doesn't divide. They don't cut the house in thirds. So now we have things to consider after you're gone. How is that going to divide in the way that I would want it to? Further, at least now, there are proposals in the Ohio legislature to change this. We have this thing called a dower interest. So if you're married and you own real estate, your spouse automatically has an interest in that real estate. So let's go back to naming 3 beneficiaries to your house. If all 3 of those people are married, and those 3 beneficiaries want to sell the property and divide the proceeds, they need their spouses to sign off too. Ooh. So that's part of the estate planning process. We want to ask those things to make sure that it's not just, how do I avoid probate? Because we get that a lot. How can I avoid probate with my house? The worst case example I've seen of that is a man came in, had 9 children, 8 of them married, and his house was basically his main asset, and he wanted to avoid probate and have a transfer on death designation for that house.
To all of them?
Yeah, equally to his children. So if he ended up following through on that, he would have had to have 17 signatures among those people to sell the house. Oh. I don't know how often you see 17 people agree easily.
Yeah, I was going to say, so yeah, what happens if 2 of them don't agree?
Yeah, you got a problem. So that's why part of that planning is not just how do I avoid probate, but does it make sense? So
So and let me go back to the will. 'Cause you said that really is only good if it's in probate.
Correct.
So what property does a will control?
With very few exceptions, a will controls only probate assets. So the asset has to be something that doesn't automatically transfer on its own, and we need the assistance of the probate court, and then the will controls it. So sometimes I have, there's a colleague of mine who says, I draft wills for people in hopes that they never need them. So they may have a trust, or they may avoid probate by beneficiary designations or so forth. But to give it a practical example, let's say that you have a will that says everything to this friend of mine, right? The assets you have, you rent a home, you lease a car, so those things aren't going to pass. You have a financial account, a checking, and an investment account. And both of those list somebody else as the beneficiary. The fact that that will names this friend doesn't apply to anything because there's no probate assets for it to control. We most often see that as a problem for people with where they say, I'm going to send everything to my oldest child, they'll know what I want. And they'll follow the will, right? Mm-hmm. So I name that oldest child as a beneficiary, thinking they're going to divide this. That may work out, but it's really creating a bunch of problems.
Okay. So again, if the will, if I don't have a beneficiary on the house or a TOD, and it goes to probate, and my will says these three people get it.
Correct.
Then you're back to that same situation, but it's through the court now.
Right. So in that situation, frequently the executor of the estate will be able to sell the property. So we need one signature, and then divide the net proceeds among the beneficiaries. So it doesn't always have to be that way. The three may want to own it jointly and rent it out or whatever, but we don't need those people and their spouses necessarily to come to an agreement.
Dave, I've heard TOD, POD. What types of things can you transfer that way?
Well, most things. So for people to understand, any transfer on death, that's the OD part, right? A transfer on death is TOD, and a POD is payable on death. They really mean the same thing. It's just what property is it's being applied to. So payable on death is a cash account, checking or savings, because we can pay that money to the beneficiary. A transfer on death is essentially everything else. So a car can be transferred on death, a house can be transferred on death, securities accounts can be transferred on death. So most of the things you own can have a transfer on death beneficiary.
And where do you go to get those executed?
Yeah, so it depends on the property itself. So for example, if you were looking to make your car TOD to someone, you would go to, in Ohio, we go to the title agency and we ask them to change the title to be my name, transfer on death to this person. That person doesn't have any rights now. They just are my named beneficiary. If I die and I still own that property and I haven't changed the beneficiary, then it goes directly to them without probate. For bank accounts, obviously you go to the financial institution. If you have investment accounts, you would do that through the financial institution that controls those. So if you have a Fidelity account, you can work with them to have a named beneficiary.
Okay, so on a will, can I do that myself? I know we talked about like healthcare power of attorneys a while back. Can I do that myself and get it notarized?
So the notary is like the bells and whistles ring. So we have people who are so accustomed to having their signature notarized as this official act, and it is. But as it relates to wills in Ohio, a notary is irrelevant. A will needs two witnesses. So occasionally we'll see somebody who has a witness and a separate person notarize it. That's okay. The notary means nothing, but we have a second witness, that person that notarized it. But if when we see a will come in and it's just notarized, we cringe because that doesn't meet Ohio law. We don't have a second witness.
So then it's not legitimate.
It's not valid. Yeah, so there are some circumstances under which we might be able to have that found. If there were actually other witnesses, they just didn't sign. But we don't want to have all of that at risk, we want to execute it properly. So like other documents, we don't, at least in my office, we don't oppose people being do-it-yourselfers. We just want to make sure, we want them to know and feel comfortable that they're doing it correctly, because we hate to see somebody, in order to save some fees, do something on their own and it not work.
Absolutely, and some of these things are pretty complicated, in my mind anyway.
Well, I think that one of the benefits of going to get help is that you'll be asked questions you hadn't thought about. So if you go to an attorney that you trust and you ask, that you say, this is what I want to accomplish, they may ask you things that you say, wow, I hadn't thought about that. So for example, in my will, I may say, this is going to go to my 2 kids, right? One of my kids passes before me. If I haven't accounted for that in the will, Ohio law is probably going to pass that one of those children's share, if they've predeceased me, to their children if they have any. But what if they're really young? If we discuss that in the office, we're probably going to say, just in case, let's put some protections that kids can't get it till they're 25 or whatever. Now the child you're thinking about may already be 35. That's fine. We just put a provision in there that says any beneficiary, if they're under a certain age, their share gets held in trust for them and only to be used for needs until they reach a certain age. So,
and I know we offer a class at the Council on Aging about all of these issues. I've probably been through it 15 times and I still get confused.
Right. It can be confusing. Yeah, but it's like anything else. People like me, it's just because we deal with it all the time. So if I had a Medicare question, then I would be lost. But if I asked you, it's like a second language, right?
Absolutely.
So we know
well,
that.
And so another question, if I have a trust, does that avoid probate?
So it does. Assets owned in trust will avoid probate, correct. So we do see an error that where people sometimes create a trust, they don't move assets into the trust. And then their main purpose of having the trust was to avoid probate, and they don't do it.
So everything has to be in the name of the trust in order for that to function.
Correct. Most often if it's your trust, it's in your name as trustee. Okay. So if somebody were looking to, a lot of times we have people who look on the county property records, and you may see that your neighbor, it's on his property record, it says Bill Jones, TR, or trustee. You say, well, what's that all about? But it's probably that he has a trust as his estate planning vehicle, and by owning it as trustee, it falls into that trust.
Okay.
Yeah.
So really, it sounds like probate is not necessarily a bad thing, but there are some bad things about it, right? Yeah,
so there can be. So most often people, if they're not going on the urban legends of probate that it's going to cost hundreds of thousands of dollars and it's going to take years, the legitimate complaints we hear are it's open, so I don't have privacy. Somebody could look up on the Greene County Greene County Probate Court website if my estate is in Greene County and see what I put on my inventory. That's true. And then there's sometimes little delays because of procedures that have to happen that may not happen in a trust or may not happen if you have named beneficiaries and that whole process. Mm-hmm. So, for example, if you named me as your transfer on death beneficiary of your house, once I have a death certificate, I can transfer that to me. It's likely going to be more process involved in the probate before that transfer can occur. There's also distinctions between who has claims as to probate and non-probate assets. The 2 largest categories we would be talking about would be creditors, so people who claim that you owe them money at the time of your death, and spouse. So sometimes we have people who maybe they marry late in life, they have a general agreement that my estate's going to be mine, your estate's going to be yours, but they don't have a prenuptial agreement or trusts. It's just a kind of a verbal thing. One of them passes first. The surviving spouse has certain rights in that probate estate of the deceased spouse. So that can be a challenge. Those rights are not present in non-probate assets. Okay. So if we avoid probate, we avoid those marital claims. And then creditors, by and large, there are some rules and exceptions, but by and large, the creditor is going to be restricted to the probate assets of the deceased. So if I pass away as unmarried and I have $20,000 worth of credit card debt, but all of my assets pass to somebody by beneficiary designation, those creditors don't have a claim against those assets, generally speaking. There are, like I said, there can be some exceptions and arguments, but as a general rule, if it doesn't go through probate, a general creditor is not going to have a right to it.
Okay.
So,
Well, in all of this, it sounds to me like there's a lot of questions that you need to ask before you make those decisions.
I think that's true.
Is there other than our class,
right.
is there a place to go to find? It sounds like an awful lot of questions.
Well, the one thing I would say is that for people who are do-it-yourselfers who would research, on any of these things, you've got to remember it's super state specific. So the rules that apply to what happens and who has claims against your estate as an Ohio resident are different from Florida, from Tennessee, from Maine. And so so we'll have people come in and they've done a bunch of research, and you have to tell them that's not Ohio law. So when we talk about this stuff, we're talking about the application of Ohio law. So if you move and you're going to retire to Georgia, move to Georgia, you need to know what laws apply, because you may have some certain presumptions that might not carry over. So
a little complicated.
It can be. That's right.
Okay. Well, that's good information to know, though, because we do have a lot of people that are afraid of probate.
Yeah, we get that a lot. And we get sometimes people say you get the people who want their loved one to execute a will, and you have questions about whether they're capable, right? So we get that question a lot. You know, my mom has dementia, but she knows what's going on. Can she execute a will? So we answer that question quite a bit. In order to be able to execute a will, you have to have legal capacity in Ohio. So that means you have to be 18 years of age, you have to not be under duress or undue influence. You have to understand the document you're executing is a will. You have to know, generally speaking, who would inherit if you had no will. The law says the heirs of your body. And then you have to have a general idea of what you have. So if you have $1 million and you think you have $1, you don't have a capacity to execute a will under Ohio law. And so that capacity could be present today and not present tomorrow. It's a in-the-moment thing. So
as an attorney, can you decide that in that moment?
So we can be a witness, essentially. So we don't have a legally binding authority to make that choice, but most of us who do this a lot, we go through a specific process where we ask the same questions of people. And also, it's rare that you would execute a will for somebody that you haven't had at least a communication or two, a conference or two to get to know them. And so then you're looking for things. But we ask a set of questions of people to make sure that they understand those things.
Okay. Great information. Thank you. Thank you for joining us for our legal chat. For any further information, please visit our website at GCCOA.org.